Justice Kagan?
That argument, Mr. Iyer, that you mentioned from Justice Breyer in Clapper, I remember agreeing with that argument. and the reason is it's a very commonsensical argument, and it's basically like, what's an ordinary person supposed to think? And what's an ordinary person supposed to do based on what an ordinary person is supposed to think? And I think here, too, you would make the same argument, is that an ordinary person, one of the funders for this organization or for any similar organization, presented with this subpoena and then told, but don't worry, it has to be stamped by a court, is not going to take that as very reassuring. In the same way that Justice Breyer said the people in that case were not going to be particularly reassured by the fact that there was a step yet to be taken. So why isn't that right?
So, Justice Kagan, I was trying to respond directly to your hypothetical that posited the 98% grant rate. We don't think that's actually what happens in state court. And you could look at the facts of this very case to see that. The state has sought an enforcement order from this state court for more than 2 years. The state court has repeatedly declined to order production. Instead, it's ordered the parties at Petition Appendix 63 to 66 to negotiate and to narrow the scope of the subpoena.
I appreciate that it's not automatic, and maybe neither you nor I know the exact numbers, but still, I'm an ordinary person, and I think, okay, these subpoenas, they're pretty regularly issued, and maybe this one will be denied, but, maybe it won't. And that's, I'm fearful of that. I don't want my name being given. So why isn't that enough?
Your Honor, I think this court has always said that.
I mean, I guess that's to say it's even, that the Clapper case was a little bit more so, but why does it have to be a little bit more so?
Yeah, Your Honor, I think the facts here are pretty far afield of that. Smith and Wesson itself, at page 894 of that opinion, Judge Hardiman noted that there was far more for the state court to do than merely implement a predetermined outcome. You can see this in how other courts have handled subpoena processes in other states. For example, Twitter, at page 1196 of the Ninth Circuit opinion, said that enforcement is not a rubber stamp of the process. So I think the facts here are just different in kind. And my friends on the other side haven't alleged anything about success rates, for example, for subpoena enforcement. And as a practical matter, I think the facts of this very case illustrate that there's not a predetermined outcome to this process. And I think from the perspective of Article III standing, this court has always said that you look at whether or not there's a contingent future action that the harm depends on. And here, there is a contingent future action it depends on.
Justice Gorsuch? Justice Kavanaugh?